Lincoln Davies. I'm a law professor at the College of Law and a member of the Stegner Center faculty, as well as the Associate Dean for Academic Affairs. It's my privilege today to moderate this panel, which is entitled Appropriate Regulatory Response to Industrial Noncompliance. And I'll just briefly introduce each of our speakers. After I do that, let me just say a few words about the procedure that we'll use for this panel. We have agreed to engage in a roundtable discussion. So first, each speaker will have 1 to 2 minutes to present some very brief opening remarks. And then from there, we will have different questions that I'll be asking each of our panelists, and they're happy to chime in as they see fit. Of course, if you have questions that are follow-up questions as we're engaging in that conversation, please feel free to ask them. And at the conclusion of that, we're hoping to save about maybe 10 minutes for open question and answer from the audience. So that's the process we'll use. And it's now my pleasure to introduce our different speakers and panelists today. First, Craig Anderson, who is the Assistant Attorney General at the Utah Attorney General's Office. Next, Walt Baker, who is the Director of the Division of Water Quality here at the Utah DEQ. Then Suzanne Bowen, who is the Acting Assistant Regional Administrator of Region 8 of the Office of Enforcement Compliance and Environmental Justice. Carol Dinkins, who you've already heard from, a partner at Vincent & Elkins. And finally, Stephen Smithson, who is counsel at Snell & Wilmer, LLP, and previously was the Senior Corporate Counsel for Rio Tinto. So please, Craig Anderson.
Thanks, Lincoln. I'm going to take a few minutes and tell you a little bit about the organization of the Environment Health Section in the Utah Attorney General's Office. I should first preface my comments by saying that my comments this afternoon are my own and are not those of the Attorney General. So with that disclosure, I'll proceed. At any rate, our section was reorganized with the reorganization of the Attorney General's Office in May. And prior to the reorganization, I was the division chief for the Environment Division. In May, the Environment Division was consolidated with the Health Section, and so our division is now known as the Environment Health Section, and we represent not only DEQ, but the Utah Department of Health. We have 2 separate section chiefs. Sandra Allen, who you'll be hearing from this afternoon, is the section chief for the Environment Section. The Environment Section consists of 10 lawyers. We're co-located with the Utah Department of Environmental Quality upstairs on the 2nd floor. Prior to that time, the environment attorneys were within some of the divisions here at DEQ. Others were located at Heber Wells. In 2012, when I came to the Attorney General's office, a decision was made to co-locate all of the attorneys together at DEQ so that we could have daily interaction with the 6 divisions and 5 boards within DEQ and the Executive Director's Office. So as a result of that reorganization, we have regular daily interaction with all of the staff at DEQ, the executive leadership team, and the boards who work with each of the divisions. The attorneys in the Environment Division all have particular expertise. So subject matter experts in air quality, water quality, drinking water, radiation control, solid and hazardous waste, all of the major programs that exist within the division. The attorneys interact on a regular basis with assisting the divisions with their responsibilities in terms of developing permits, assisting with permit appeals, enforcement actions, and appeals of enforcement actions. So that's essentially what we do.
Great, thank you so much. Walt Baker.
It's good to be with you today. I do so, and when I say that, knowing that I'm violating the dress code for my division today in wearing a suit, past one of the members of the department as I was coming down the stairwell, and he said, "Well, you're all dressed up today." And I said, "Yes." And I said, "You are too," because the irony was he was in a kilt. But but in any event, I want to talk about, lay the groundwork for some of the discussion and perhaps some of your questions today. Excuse me. Under the public trust doctrine, we protect the waters of the state, both surface water and groundwater, for the interest of the citizens of the state of Utah. Let's bring up that first slide. I don't have the clicker here, but if you can just bring that first slide up. So you can see the myriad different types of waters. We've got urban waterways. We've got our protected waterways that serve as drinking water sources in our high mountain areas. We've got waters in our deserts. We've got ephemeral and intermittent streams that are not always there, and we've got our groundwater. The mission of the Division of Water Quality is to protect all of those waters. We do so through the Federal Clean Water Act and through the Utah Water Quality Act, both federal and state authority. In my division, there are 7 different sections with different responsibilities. I'm going to talk about the 3 regulatory sections. We've got 2 surface water permitting sections and a groundwater protection section. So the issues that we're talking about today will mostly be centered in those 3 sections. There are 4 main aspects to tools that our regulatory sections use to administer both the federal and the state programs. The compliance assistance, and that means outreach to communities and helping the regulated community know the rules and to be able to follow those. Permit administration, so that's the widget we make. We help develop permit requirements and work with the regulated community, have the infrastructure and permits for permits to administer them, store, review, report on those permits. We do monitoring. That can be monitoring in the field as well. It can be inspections and audits to validate permit compliance. And we have enforcement activities that can be warnings or any legal action, penalties, fines, etc., or orders. So with that, I will welcome your questions later on.
Thank you. Suzanne.
Hi, I'm Suzanne Bowen. As Lincoln said, I'm the Acting Assistant Regional Administrator for the Enforcement Office at EPA Region 8. That's the Rocky Mountain region, a 6-state region. We've got about 500 folks that are regional employees. In the enforcement office, there are 100 people, about 35 attorneys, and the rest are everything from admin staff, inspectors, toxicologists, and folks that help develop our cases. I wanted to reflect on an ABA conference that occurred back in October, where Administrator of the EPA indicated that laws talk the talk, but enforcement walks the walk when it comes to EPA. And it was a great message because there, frankly, had been questions about, where does this administration support enforcement? And with a resounding yes, we heard from the administrator that, yes, indeed, this is a critical element of what EPA does. And so just wanted to touch on the 3 enforcement goals that the agency has set up that we're focused on. The first one is tough enforcement. And what tough enforcement means is taking a look at how we achieve a deterrent effect. So we have limited resources, but the focus is on looking at the most significant violations and targeting them. The second piece, and Carol touched on this earlier, something that the agency is looking at, and I think industry is as well, is what we call next generation compliance and enforcement. So we're looking at things, when we do settlements, looking at things like e-reporting. How can we take that human element out of the equation to the extent possible, so we're getting reliable information on reporting, and redundancy in systems, so you don't have someone that failed to flip a switch or the wrong switch. So that's, we have e-reporting, also advanced monitoring, things that are out in the field, fence line monitors where we're getting real-time information, again, that is can be coming in on a continuous basis. So again, we're not necessarily relying on a human element, knowing that, for example, in our air enforcement program, we've got 7 people for 6 states. For our Clean Water Act 404 wetlands, we've got 3 people. So we don't have the resources to go out and be doing that work. So we're looking at how we can use this next generation technology. We're also using it to improve transparency. So that means, we're getting settlements where companies are saying, we're going to fix these, or we're going to do an inspection on our tanks in this oil field, and then we're going to disclose that information to the public. So that next gen piece, I think, is something better enforcement, all that. The third piece has to do with fighting elephants, and we're really working on stronger and better partnerships with both states and tribes. So we're coordinating better. We are not trampling the grass, the regulated community, but we're backstopping. The EPA has a critical role in ensuring we can backstop states and tribes and helping them have stronger enforcement programs. So those are kind of the 3 goals that we're focused on. Thanks.
All right, terrific, thank you. Suzanne?
Carol.
Sorry, Carol.
Suzanne, I'm very interested to hear that the administrator was asked whether EPA was going to do enforcement cases. That was the same question I got 33 years ago when I went to the Justice Department. Is the Reagan administration going to enforce the environmental laws? And unequivocally, I said at every turn, any chance that I could speak out, of course we will enforce the environmental laws, because the regulatory scheme is very expensive for companies to comply with. And if my clients are spending a lot of money complying with the law and their competitors are not, and are not subject to enforcement actions by the government, that is not a level playing field. And that is not the right way to deal with the regulated community. And I continue to believe that to be the case. When I was at Justice, we created the environmental crimes section. And there had been one lawyer from Justice who worked half-time at both EPA and Justice trying to develop a nascent criminal enforcement program. And by the time I left, we had, I think, about 8 or 10 lawyers at Justice, and we had the first class of NEIC investigators at EPA to conduct criminal investigations and prosecutions. And we felt at the time that was critical, because the environmental laws by that point in time had matured, and they were at least 10 years old, and the regulatory programs should have been understood and should have been complied with. And we felt that where there were instances of death, serious injury, severe environmental damage, or big risk to the public, that there should be a mechanism to enforce criminally against companies who had violated the environmental laws. And we had, for example, just a month before I was confirmed, an explosion in the sewer system in Louisville, Kentucky, from something that Ralston Purina had put down in the sewer system, and it was not the first time that had happened. And the only reason there were not injuries or fatalities was that it occurred at 4 or 5 a.m. when people were not on the streets. And we felt that was an excellent example of why you need criminal enforcement. Now, to come forward these decades to today, there remains a place for criminal enforcement, but enforcement needs to be much broader, and I think what you're doing at the agency to look at the next generation so that enforcement is not just bringing a lawsuit or a criminal prosecution or an administrative action, but really finding the problem as soon as possible. And we have had a number of settlements for fence line monitoring. One of them was at the Texas City refinery. That's a hard thing for a company to swallow because they say, well, all kinds of other stuff is going across that fence line. It's not just mine. But those programs can be made to work. And I'm a strong believer in voluntary disclosure when a company finds that it is out of compliance with the law, because I think that the regulators need to know that, and the company and the regulators need to negotiate the best way to get the company back into compliance, and that needs to be done with enforceable agreements, and it needs to be done in a way that is going to provide the best result for compliance with the law.
All right, thank you, Stephen.
Sure. There's first a comment, considering I'm listed on here. So I'm not speaking on behalf of Rio Tinto or Kennecott, and I don't really intend to talk about Rio Tinto or Kennecott. Lionel, you asked an interesting question about pipelines, and it reminded me of a discussion we had amongst this panel about a week ago in terms of, can industries expect not to have environmental issues? Can they expect not to have noncompliance? Is that a realistic kind of goal? And we may talk about that a bit. But it's certainly, I think, fair to say that's the goal internally of large, credible industrial companies at this point. They don't expect to have problems. They plan for them, but they really don't want them. They don't really tolerate them, particularly internally. And yet, because of the complexity of systems, the uncertainty of the chemistry, the biology, the physics of systems, things do go awry nonetheless. And sometimes catastrophically, as we were talking about this morning. And a lot of, it seems to me, how you deal with these non-compliance issues really sets the stage for how you deal with some of those other issues too. That it's really critically important to deal well with regulators on what I'm going to call for the moment sort of minor non-compliance, or even issues that aren't really non-compliance maybe, but nevertheless are unexpected, in order to generate the kind of working relationships you need with the regulators and also with the the activist or NGO communities, so that you can deal with real problems when they do arise.
Okay, so I think our intent here was to give you a little bit of an introduction to the different perspectives you're going to be hearing from, and a little bit about the compliance process, which I hope we have now done. So the first question I have for the panel is, if you could describe what you think the enforcement process does, what it's supposed to be doing, and what principles guide it. And also, if you want to speak to the question, what the relationship should be or is between the federal government and also the state governments in enforcing environmental statutes. Okay.
I'll take a shot at that. One of the things, before I came to the Attorney General's office and assumed the position as the Division Chief for Environment, I was with the Salt Lake County District Attorney's Office. And the DA's office in the Civil Division also has an environmental regulatory program that's part of the public health program. And one of the distinct differences between what I did at the DA's office and what we're doing here at the Attorney General's office is under county ordinances, health regulations, and the things that are authorized for local government to do under Title 17 of the Utah Code, those activities are generally referred to as code compliance. There are a list of activities, regulated activities, and there are a list of violations that occur if you don't follow the cookbook for whatever the regulated activity is. The difference in terms of what we do in the Attorney General's office are primarily DEQ in the 5 divisions have permit programs, and regulated industries operate under the terms of permits issued by the various divisions. So in terms of the legal work that we do, both in assisting with the interpretation of the statutes in Title 19 and the administrative rules that are adopted by the various boards that support the divisions, goes to compliance with issued permits, as opposed to code compliance, which is primarily enforcement. So in terms of what we do, we assist with the interpretation of the regulations, interpretation of the statutes, and where there is a difficulty, that difficulty usually occurs when an inspector is out in a field looking at a facility to determine whether or not that facility is complying with the terms of a permit that's been issued to operate. So, if an issue comes up, the first thing that will likely occur is that that inspector will either notify the facility verbally or in writing, typically both, of the non-compliance that's been observed, and then we'll try and work with the facility to bring them into compliance. If that does not occur, then the enforcement process can occur, and that may result in the issuance of a notice of violation, which triggers an administrative hearing process. Now, recently, there were some amendments to Title 19, which essentially create a new administrative hearing process for the Department of Environmental Quality for permit reviews. That's when a permit is issued, or enforcement reviews, when there is a notice of violation or a difficulty that occurs and the agency issues an enforcement action. So typically, the majority of enforcement actions that are taken through the division, the majority are going to be administrative proceedings. The next tool that we have is civil litigation. If there is, for instance, as a result of a notice of violation, typically they're resolved through a stipulation and consent agreement with the agency, which is essentially a contract about how you're going to resolve the problem and how business is going to be conducted moving forward. If, for whatever reason, there is non-compliance with the terms of the settlement agreement, we'll go to district court, file a complaint, and then seek to enforce the terms of that consent agreement. So that's where civil litigation comes in. Also, if there is a need for injunctive relief, if there's a need to get a TRO or a preliminary injunction to prohibit some activity that's occurring, obviously that's the course that would be available to us and the direction that we would take. Very rarely there are opportunities where if there is a regulatory gap, as Amanda was referring to, we will look to public nuisance, various tort type claims that can be brought in civil litigation. That is something that's available to us, something that has been exercised from time to time, but is not something that we look to on a regular basis. The third element is obviously criminal prosecution. Each one of the regulatory programs under Title 19 does have criminal violation provisions, as does the general provisions in Title 19, Chapter 1. There have been criminal actions that have been initiated, but those are by and far, further down on the regulatory scale because generally, in order for criminal prosecution to occur, we have to have knowing, intentional acts, a real effort to violate the regulatory requirements under the various programs. In my course of work with DEQ, prior to coming to the AG's office, I'm aware of circumstances where those actions have been taken, not only by the state, but the state together with the federal government through EPA and the Justice Department. But that is, a fairly rare occurrence. So that's essentially my experience with enforcement at the state level.
Yeah, well,
Craig was talking a lot about process, but purpose. As I understand the purpose and understanding the Clean Water Act and Utah Water Quality Act, purpose is, we've spoken about this, a deterrent for pollution. It is to protect the asset, which are the resources of the state. It is to provide fairness and equitability relative to the administration. So it's as we've talked about, a level playing field. The state, in my opinion, is on the front lines, and we've heard about backstop on federal authorities, even though we are delegated by EPA to administer aspects of the Clean Water Act. It is the state that's on the front lines with oversight by EPA, with the potential for overfiling if we are not on the same page or have not taken the steps that EPA feels are adequate.
I don't know if Carol or Suzanne, if you want to speak about this from a federal perspective.
Sure, I can just add a few things to what was said. Under principles, the two that were mentioned, level playing field and deterrent effect, are definitely what motivate EPA to take enforcement actions. When we decide to take an enforcement action, typically the first step is trying to make sure that we have a violation. So sometimes we're responding to an incident, like we've talked about this morning. Other cases, we have a tip line, and we get information from that tip line that we either go out and do an inspection, or we issue, because of the short staff in terms of our inspectors, we'll issue information requests to a company. Ask them what they can tell us about that. We'll get that information in and then make a decision about whether or not we think there is a violation. We don't send then a notice of violation. We used to, but then the Sackett decision came about, and now we issue letters of, or potential letters of violation. I think it should be, it's the LP, I don't know how you say it, but so the letter basically says to a company, we think there may be a violation. Now, why don't you tell us if we have our facts right? And we basically lay out what we think the facts are, what we think the violations are, and we asked for feedback. And that's a time when there's actually a fair amount of, or there can be a fair amount of interaction between the regulated entity and EPA. They may come in, they may send a letter back, but we're trying to kind of hone in on what the facts are and then make the decision about that. And then we get all that information, we mull it over with our inspectors, our attorneys, the case team, lower management, and it kind of bubbles up the chain, and we decide at weekly case review, are we going to take this case and what are we going to do? So an information request is not considered enforcement action. The enforcement action comes later. We decide there is a violation. A company says we did it. Next step is, well, we can issue an administrative order on consent. That would be if there's injunctive relief that has to happen. If the company says they're not interested, we'll try with a unilateral administrative order. Sometimes the injunctive relief has already occurred. You've heard this morning about cases where the company has dealt with the cleanup. And then our job is to get the penalty. This is, again, if we have direct implementation, it's not a state authority. Or, for example, on tribal land, we're the primary entity that's responsible for enforcing those federal laws on private land. So that's a little bit more about kind of the process that we embark on.
So, Stephen, I don't know if you want to talk about your view coming from representing a private company, and now I assume those are typically your clients as well.
Sure. And I think you asked whether you'd prefer to be regulated or have enforcement from the state or the EPA. Here in Utah, generally from the state, first of all, for most of the laws, they've got primacy other than the tribal areas, so it legally is appropriate. But practically, it's probably a better choice, too. They have more resources to devote to addressing the issues. It'd be great if they had more resources still. They tend to know the facilities better. They tend to know the state better. So they tend to be easier to deal with because they don't need to be brought up to speed necessarily. So you can move things along. On significant noncompliance, though, you want to work with the EPA, even if they don't have direct jurisdiction. You want to let them know what's going on, keep them informed. The state's going to be talking with them most likely. And it's helpful for everybody to be on the same page. To avoid, as Walt mentioned, so for instance, an overfiling kind of situation. Open communication is absolutely your best friend in those sorts of serious non-compliant situations.
So you mentioned sort of catastrophic incidents. I know that was the panel earlier this morning, but let me ask a question that sort of relates to that. Obviously, when there's a big event that happens, it's right in the limelight of the public, and a pipeline leaks in Liberty Park or wherever, and it's on the front page of the Tribune for weeks. But what about what the public should really expect in terms of enforcement and compliance with environmental laws in general? For really complex operations like industrial operations are and energy operations are, can we really, as a public, expect 100% compliance? And if not, then what should we expect, and what role does enforcement play in that?
We're going to go down the table, or just anybody?
Go for it, Walt.
I think there are different levels of noncompliance. There are noncompliance, for instance, in a permit that some entity has, be it industrial or municipal. Significant noncompliance can be triggered because of failure to submit a report, or the results of the monitoring under a permit, which we call a DMR, discharge monitoring report. You get 2 consecutive quarters of noncompliance with even a reporting violation like that, you are on the significant noncompliance list, and that's automatic. The computer will do it independent of our request or independent of judgment. But there are these catastrophic events where there is a discharge that was not anticipated. There's not a permit really involved, but there's a violation of the Utah Water Quality Act of discharging to the waters of the state, including groundwater, that either is a direct discharge or the potential to affect the waters of the state. And there are different colors of that. If somebody spills 3 teacups of ethylene glycol and it goes into the stormwater system, that's a different issue than maybe a catastrophic blowout of a production well that influences the Green River. So a lot of judgment goes into, and discretion goes into, enforcement activities, what was the nature of the spill, what was affected, public health, the environmental aspect of that, the magnitude, and we exercise discretion of how to approach those enforcement activities.
Great.
I would add that it doesn't have to be catastrophic, because I had a federal case that involved, over the space of 2 or 3 years, 40 very, very small spills, some of which were just a sheen on the water. But the Coast Guard felt that our client was not sufficiently concerned about preventing those spills, and it just, even though if you had added them all up, it probably wouldn't have been a barrel of hydrocarbons, they still brought a criminal action under the Clean Water Act, because they felt that the repetitive nature of the noncompliance was sufficiently severe that they needed to make an example of our client and provide deterrence through a criminal action, as well as to punish our client for not having prevented those very small spills over a several-year period. So it isn't just the catastrophic events.
And can I add one thing to what Carol said there? A violation of the Water Quality Act, we've got numeric standards of numbers, levels of toxics that can go into our water without harmful effect. All our permits operate under those kind of standards, a numeric, but they also operate under a narrative standard, which says you can't visually impair the waters of the state. An oil sheen, for instance, that you may not be able to detect. In fact, the effects of that on the aquatic habitat or on public health can in fact be, will in fact be a violation of our narrative standards that says you can't throw tires into our water, you can't pour oil, can't cause harmful blooms that would impair visually our waters. So that's an aspect of the Utah Water Quality Act too.
Yes, sir. So the question is about cleaning up mining sites or other contaminated sites, and the possibility of Good Samaritan provisions to limit liability for those willing to do the cleanup.
That's a great question, and we've been, even of late, we've been wrestling with the issue of Good Sam provisions and protections, and we've got that citizen suit concern that someone's going to jump in, and you know, we're trying to figure out how we can encourage non-responsible parties to come in and take action to maybe operate a cleanup facility. They may want to redevelop the area and do some really great things, but we've got concerns about giving no action assurances and have basically, at least at a regional level, been told, we can't just do that lightly. If a company wants to come in and enter into a much more formal settlement agreement, then we can consider that. I mean, I think that goes to, we're sort of expanding the scope of the authority in terms of EPA taking a specific action against a regulated entity. We're looking at how to bring new people into the fold and then basically settle some liability by saying they're going to do this. Usually there's a lot of activity that's requested, a lot of consideration in order to get one of these settlements, and often that drives that other party away from the table because they're not willing to, coming in as an innocent party, not willing to say, oh, okay, we're going to stay on the hook in perpetuity once we start this cleanup action.
A comment, maybe a little off topic for our panel, but it's an interesting question, and it makes me think of, if you know the book The Cat in the Hat by any chance, and the cat comes in and he moves the stuff around and it makes it worse and worse. Well, that happens. And I know I've litigated matters where folks have come in and cleaned up and made it worse. So it's not such an easy situation necessarily to just absolve them and then let them scatter things about, just as a thought.
I would have to probably defer to my friends over at Natural Resources to identify the number of abandoned mines, but I know Colorado has been a leader through the former Senator Udall with the Good Samaritan Act. And it's a concern largely, to me, it's not a Utah Water Quality Act concern, it's a Clean Water Act concern and a CERCLA concern, how to insulate those Good Samaritans from third-party lawsuits and other liability to go in and clean up. Now, we work through watershed groups and we provide funding through watershed groups to do those voluntary things and to encourage that, but third-party lawsuits is a little out of our wheelhouse, and we can't it's not something we can grant or insulate them. Now, with other aspects, for instance, failing on-site wastewater disposal systems, we go in and we can insulate individuals if they will enter into agreements to replace, repair, maintain these systems so that we don't have E. coli problems in our rivers and streams. Then we can commit to holding in abeyance any enforcement activities. If they'll do their part, we will do our part. So a carrot and stick. But relative to abandoned mines, we're getting into an arena that is a very tough nut to crack, as Colorado has discovered over the last 20 years as they've tried to have a movement under the Good Samaritan Act.
Another issue, Pat, that comes up in regard to not only the safety issues associated with the abandoned mines, but acid mine drainage, and particularly in Little Cottonwood Canyon, where a lot of the water that comes out of the old mines goes into Little Cottonwood Creek. And there have been efforts, there was a study that was done, and then there was kind of a project that was done. This has probably been about 10 years ago, where there was an artificial, it was called a fin, which is kind of a biological, using certain types of plants where water was diverted into the fen. The purpose was for the plants to uptake heavy metals and then buffer the acid before the acids that were in the water before it was discharged into Little Cottonwood Creek. The study really never progressed beyond just kind of a science experiment, for lack of a better word, because there was concern associated with potential problems with, a waste that would be generated as a result of that project and how it would be disposed of and who'd be responsible for it. So there are lots of good reasons to go along the path that you're suggesting.
Yes, sir.
My question relates with the state, federal government working with the state here in Utah, particularly on the Ute reservation, and particularly the Uncompahgre reservation, where the state of Utah has on 2 occasions, now intends on a 3rd, to issue permits for strip mines and tar sand or oil shale processing facilities, including dumping water without a water discharge permit based on the theory that there's no groundwater. Now, I understand the tribe has no enforcement authority. Can the U.S. EPA step up? Does the U.S. EPA have a program to step up and protect the reservation lands in Utah when the state themselves are permitting strip mines and processing facilities to discharge without water discharge permits?
So the question is about approved energy extraction activities on Ute tribal land and the relationship between the state and federal government.
I remember Suzanne, to your left, Walt signed the document that says there's no groundwater at PR Springs. I personally been out there. I drink that water that comes out of the ground at PR Springs. I think he's up in the night on this issue, but I wonder what does the U.S. EPA say about the state permitting these projects on the tribal lands?
You want to start with that?
I think it's to you, but I'll field, if you've got a direct question for me, that's fine, but I think
Yeah.
that's an EPA question.
Yeah, I know on oil sands or tar sands and oil shale, that's an area where our RCRA folks are now kind of looking at EPA jurisdiction on some of those Red Leaf PR Springs. So that's an issue that's sort of before us now, trying to look at EPA authority. And I certainly think we work with, we're in direct communication with the state, with DOGM and others at Utah on how they're dealing with the facility and our facilities or potential facilities, and trying to make sure we're on the same page. Those, given that those are sort of new issues, a new resource we haven't dealt with, EPA headquarters is getting involved and trying to, figure out where is our jurisdiction and what can we do. Certainly, we've got a critical trust responsibility to the tribes, and working hard to engage the tribal leadership, not only in UNO but other tribes, to understand what tribal leadership wants. And then, in addition to the tribal leadership, we've got our program that's our environmental justice program. So it's not just about tribal leadership, but those members of the tribe that are overburdened and impacted. So those are all considerations in addition to kind of the state-federal role that we're working on. And I don't have the specifics about that one, sir, but that would be one I'd say we're engaged and we need to be engaged. And where we, with any state in the region and in the country, if we've got a kind of state review framework, we're working, our RCRA folks, our water people do regular oversight of the state through, it could be from our ongoing relationships, or it could be from concerns or complaints from citizens. That gets us further engaged, and so we're on the phone finding out, what have you done? Why have you done that? Can you explain that? We've got someone coming in saying they've got a concern about this approach. And so, so we look at it, as I said, as a kind of we're a backstop, and so we want to make sure that the right authority is being used. And when we get into some of the jurisdictional issues about state and tribe, we also have to look at cases where a tribe and a state often have agreements about the state coming in and exercising authority sort of, I'll call it on behalf of the tribe, but on tribal land. And so that's a factor that varies from reservation to reservation about what that relationship looks like.
Well, it would seem from the federal perspective, there would also be an overlay of Department of Interior jurisdiction as well through the BIA and leasing of tribal lands, I would assume, as well, right?
I think in some of the cases, you've got BLM issuing rights of way, so to some of these projects. So we definitely are working with BLM. The hat I wore before this job was in the NEPA program, and so working really closely with BIA as they're developing. If they get a request from an entity to grant this right away, and they're coming in and we're saying, these are the things we need you to consider. These are the things that you need to address about that potential environmental impact, and then how it's going to be mitigated. So, and then figuring out, making sure that they're contacting community, working with the state, making sure, and BIA certainly has a role with their trust responsibility, and as a one agency that speaks for the tribe, and also has some authority on those tribal lands.
So I don't know if you wanted to speak to this question or not, Walt. If not, we can move on to the
Just a brief statement. The issue really at PR Springs that was litigated wasn't that the state issued a permit. It was that the state did not issue a permit. We indicated it was a permit by rule, that our determination was that there was a de minimis impact and potential impact to groundwater because of depth of groundwater, because of the nature of the materials that were involved, and so we did not issue a groundwater permit, but we always have the reopener clause. We can issue a groundwater permit for that or other determinations that we've made to be a de minimis impact if the facts support doing so.
Okay, so we've maybe we can come back to this question in a minute. I want to move on if that's all right. So we've had a couple of questions about more specific issues, mines, tribal lands. We started broadly. I'd like to maybe go back to a little bit of the broader discussion in terms of what compliance looks like and enforcement looks like in this context. I wonder if the panel could speak to the question of the relationship between reporting obligations from those who are regulated, as well. We've mentioned notices of violations, or ELPs, I guess EPA calls them now, as well. And so what that relationship is, what it looks like, what you can reasonably expect private entities to report. And of course, I would think from a private entity's perspective, if I report too much, now maybe am I bringing on the risk of a notice of violation or ELP for me?
Well, I'd like to address that because I advise clients on whether to report above and beyond what they're required to report. And there are a lot of instances where it's in the best interest of the company to do that, because if they are in violation of the law, they need to get out of that violation position and come into compliance. And a lot of times, as I said in my remarks earlier today, that requires a formal agreement with the government. There are instances where you might look at some event or some circumstance and say, they're not likely to find me, and so I'll just clean it up, correct it, and move on. But I think that sort of consideration needs to be carefully vetted with experienced environmental counsel, because I think that is not normally a good way to proceed, and that it's very risky. And a company, I think, does much better to go to the regulators and say, we have this circumstance or we have this event that occurred, and we know that that was not in compliance, and we've done what we can to correct or mitigate it, or we want to, but we want to make sure that you're agreeing with what we're doing with that mitigation. I think that even if the regulators and the prosecutors impose a penalty, that you are still better off than trying to hide something, because it's a matter of a long-term relationship with the regulators and a matter of a long-term relationship with the community that you're in. And what Suzanne told you about the tip line is a very real situation. There have been any number of times that we have gone to regulators and said, we've had this happen or that happen, and we've come in to tell you about it in a voluntary compliance, and we want to get a corrective action plan, or we want to enter an agreed order or some other arrangement to come into compliance. And on several occasions, months later and even years later, we have discovered that in fact somebody did give a tip to either the state or the federal government. And if we had not gone in, things would have been much, much worse. And so you just can't assume that things will not be discovered, and you need to alert your clients to the real risks of them being discovered when you could have made a voluntary disclosure.
One thing that I would add to that is that in Utah, under the Water Quality Act and under the Solid and Hazardous Waste Act, there are penalty policy factors that apply to the negotiation of settlements if there is a violation. And one of the elements that goes into the calculation on the penalty policy factor is voluntary compliance and good faith efforts. And so, again, under the worst case scenario where you report something that turns out to be or result in some sort of a violation, the penalty factor is going to be adjusted in your favor under the factors that are considered for administrative penalties.
It's
Steve,
the
you
same
had-
thing at the federal level, and I've benefited from that.
All right.
Yeah,
Steve?
I just want to emphasize, or further emphasize what Carol said. I mean, it's a matter of trust. If you're out in front of things that are small, that aren't in compliance issue at all, your regulators are going to trust you more. The community is going to trust you more. And then if you have a problem, you can perhaps resolve it without getting a violation. Or if you get a violation, because that perhaps resolved without such a penalty. There's also all sorts of practical value in disclosure review and things are issues that aren't a compliance question necessarily. Perhaps the regulators can help you fix them, help you think about them, help you avoid them in the future. There's almost never a good reason not to talk to the regulators about these issues. You'd never know when you're going to need that trust to be built up, and doing it when you don't need it is really the right time.
I'll just echo that. We've got a settlement that was done up in the Bakken in North Dakota with oil and gas operators. It was basically not a settlement, a permit that applied to 9 operators. What we found is that actually some of the operators are ratting out several that are not considered good actors. They don't want to have the blemish on them. So they've contacted EPA, they've contacted the tribe, the Corps of Engineers, entities that are out there to say, hey, take a look at these folks. And so as a result, we've gone out and done inspections, and sure enough found that, and then coordinated with the state, because the operators aren't just operating on tribal land. In this case, it was tribal on the Fort Berthold Reservation, but contacted the state. They went out with inspectors and found, this is a bad operator. So that operator is kind of recalcitrant and not willing to kind of play by the rules everyone else is playing with. You're seeing that in that industry that are good actors. You want to preserve their good name, and so we'll turn in others.
So on the last question, one thing you mentioned, Craig, was the possibility of settlement agreements. So let me ask a question about that. In terms of settlement agreements, from your perspectives, both in government and outside government, when have you found that the regulators are willing to enter into settlement agreements that differ from or maybe exceed their normal regulatory authority? And what are the benefits and costs of trying to navigate those types of negotiations?
Well, speaking generally regarding the settlement agreements that are typically negotiated, again, they're usually in the context of a notice of violation. And again, getting back into the procedure a little bit, what occurs when a notice of violation is issued or a notice of agency action is issued, either one, is that there's an administrative process that's initiated. And under the new administrative hearing procedures, one side or the other can request the appointment of an administrative law judge who essentially conducts a quasi-judicial proceeding to resolve the notice of violation. Typically, what can occur is that the parties, prior to entering into that quasi-adjudicative process, can sit down and negotiate the terms of the resolution of whatever the violation is. And typically, in most circumstances, that includes fixing the problem, whatever the problem was that resulted in the violation. Typically, it involves the payment of a penalty, and as I mentioned earlier, there is the penalty policy that establishes how much that violation may be based upon the maximum statutory penalty for each one of the programs in Title 19. And then there may be what's referred to as a supplemental environmental project, which is a voluntary project that may be undertaken consistent with the requirements of the administrative rules that may reduce the amount of the penalty, but may also result in an environmental benefit that would otherwise not be achievable. And so there can be the negotiation of a settlement. If there isn't a negotiated settlement, it goes through the quasi-adjudicative process. The administrative law judge issues a recommended decision, and the recommended decision goes to the executive director, Amanda Smith, for final determination, and then it proceeds from there. But that's typically what happens.
Let me just add a couple of things to what Craig mentioned. If we get to the point where we issue an NOV and there is some kind of penalty associated with that, the penalty takes the form of two components. One is the gravity component, and there are A, B, C, and D gravity components, A being the top of the list or the most egregious, and D being, some other less egregious. That's the gravity component, and then there is the benefit component, the economic benefit component. So that is additive to the gravity component. If we feel like that some preventative measures should have been taken to prevent the violation, and that there was a benefit financially that was received by avoidance, then we calculate what that benefit is and add that to the gravity component. And that's all spelled out. So the negotiation process begins as we look over that of our assumptions, or is there some agreement that we can come to? If there's absolutely no agreement, and then we pursue some of the administrative processes that Craig outlined.
I'll just add that another thing that we're seeing is reflects on the comments that were made earlier about social license to operate. And so what we're seeing is that a company will look at sort of what the community is, and especially in the overburdened communities, a company will identify, with EPA's help, we'll give them some suggestions, but a project that will benefit the community. So it could be building a health clinic in a community. It could be retrofitting buses, so that they're, burning cleaner fuels. Things like that, they're going to affect a community that's got a lot of children in it, or, if there's concerns about, air violations, they're going to look to a benefit to that community. Often there will be some type of community outreach that the agency does to sort of gather input. There's NGOs that are advocating for the community that will come in to EPA and be asking for these types of supplemental environmental projects to kind of address that harm to the community that was posed.
And is that something that the state looks at regularly in terms of settlements? Is community benefit projects or other types of non-monetary relief?
Correct, and we do a number of supplemental environmental projects in lieu of penalties that go directly to the state general fund. It's not, we don't parse these out for raises to employees. There's not an increase to my budget as a result of penalties. They go directly to the general fund of the state. So we encourage environmental projects, but that is totally at the discretion of the violator. And there are some parameters there. Our administrative rules that govern supplemental environmental projects, and it's in R 317-1-8, I think, and you can see the penalty policy. That's, it's pretty clear. But the projects have to be pretty much tied to the nature of the violation. So I've interpreted that meaning if we've got a water quality violation, I can't build a hospital with it. necessarily. Now, we use broad discretion on what kind of projects we can do, but there's a limit to that discretion.
Could you give some examples of some of those projects that have happened in the past?
Yeah. We had, some major ones relative to the Chevron spill. We've entered into significant value supplemental environmental projects along the Jordan River, in the watershed of the Great Salt Lake, along Red Butte Creek. Similarly, we went out for proposals for projects on the spill up at Willard Bay, and some of those are underway already. And they are far-reaching. They not only are within the confines of the spill area, but and many of the dollars went to projects there. But within the watershed itself, we felt that we wanted to broaden the solicitation of projects, and so some of them are educational projects, some of them are infrastructure, riparian restoration projects, just any number of projects, and they totaled a fairly significant dollar amount.
Steve, I don't know if you could speak to this question from the private sector perspective, but are these types of projects something that are typically considered by private entities, or only in sort of certain circumstances? What might prompt a private entity to want to do this rather than pay a monetary fee?
Sure. A number of particularly large clients I've worked with like these sorts of projects. Often somewhat, I think, cynical or worried whether they'll actually ever come to fruition, that there'll be a regulatory impasse that prevents them from happening at the last minute. But if they can, they're better from a corporate standpoint. If you're going to spend X dollars in a penalty or 10X dollars in a project that has a benefit, that's typically a better message for the corporation to engage in. Something they can say, well, we did this. And they like that, generally speaking.
I would say, though, that in the supplemental environmental projects that we've done, it has not been a matter of X and 10X. It has been a matter of X is the penalty, and that either goes back to the general fund or a similar scale project performed. So if there was $1 million penalty, and we negotiate that there's a $300,000 penalty that goes to the general fund, and we'll do $700,000 of environmental projects, not 2 times that or 3 times that or 4 times that. In addition, our policy says that there cannot be an advantage to the violator. So they don't get brownie points or credit for doing an environmental project. There's no signage, no attaboys for that, because we don't want to encourage, frankly, those kind of attaboys for violations. And so we go out of our way to make sure that there's no notoriety associated with this project. And that's why it's at the discretion of the violator if they wish to pursue those.
You might reconsider that. I know some really good attaboy signages that resulted in some very good projects.
Well, but at the federal level, it's quite the opposite. In my experience, we had to put up signs that said that this project was done as a penalty for violation of the environmental law. And you specifically are forbidden from getting any tax deduction for it. And we generally end up paying more for the SEP than we would for the penalty. EPA's got a penalty policy. EPA has what we call the SEP police to make sure that a SEP is really one that fits the criteria for the agency. And I would caution you, there was a mention about retrofitting buses, and I had a client who negotiated that and did not approach the local entity that had the buses to find out whether they had the mechanisms for repairing the buses, and they didn't. And it was much more protracted event than one would have thought, because the client had to go back to EPA and renegotiate because the local governmental entity couldn't accept the SEP because they couldn't repair the buses if and when they didn't work. I would also mention at the federal level, in the criminal context, there's an alternative minimum fine provision. And that accounts for economic benefit to the violator, and it can be an enormous number. And so if you're ever involved in a criminal case and you're looking at penalties, you must be attentive to that piece of the law as well.
Suzanne, maybe I could just ask you briefly the show me the money Jerry Maguire question as well. So we talked about the money for state penalties going to the general fund. I assume everyone here would not be happy with Congress getting a raise from monies that go to the federal government for violations.
Well, then they should be unhappy because generally the money's not going back to EPA. So that's unfortunate, but we're not supplementing our budget with the penalties that we collect.
Right. But it also goes to just the general fund, general
Goes to the
budget of the
Treasury.
government, the Treasury. Okay. So we have just over 5 minutes left. I don't know if there are any other questions from the audience. Yes, ma'am.
You said that, Suzanne, you said there's a lean workforce. Budget restrictions or restrictions on people entering this.
So the question is about the lean workforce at the EPA.
So it's the former. The issue with our workforce is associated with our federal budget, and it's not the lean workforce. We just are people interested in this career. We just advertised for 2 attorney positions and had 350 applicants. And it was entry level, and we had applicants with 15 years experience. It's a great place to work. I've been there 26 years and counting, and we're really hamstrung. We have a lot of the budget is passed through, so we send money to states and tribes so that they can implement their programs. We have grant programs, and Department of Justice also gets some of the funds, and so it's really about the money that we have to operate, and then the FTE. And we recently did a buyout, and then in the region, and then there's another set of buyouts that's being offered in headquarters in the region at this point in time. And a lot of, for example, our attorney cadre, 50% are eligible for retirement within the next 5 years. So what's happening is people are leaving, and then we're not getting the ability to rehire. And so that just means we're shrinking and trying to figure out how we can do the same type of work, or as close to work with fewer people.
Yes, sir.
You address disadvantage municipality violation. I'll forgive all the fines if you take my federal money and rebuild.
So the question is about disadvantaged municipalities that are in violation of a statute and the possibility of receiving funds to fix infrastructure and come back into compliance.
Well, a component in the negotiation process is the ability to pay, whether that's a community, a political subdivision of the state, or an industry. And sometimes we have to get into tax records, et cetera, to validate the ability to pay. But that's an element that's associated with our settlement and negotiations. The second half of the question relative to federal grants,
I'll waive all your fines and you'll take money to rebuild your system and we'll give you the money.
well, I'm not familiar with that on the federal level relative to assisting communities. The Water Quality Board assists communities to deal with pollution projects. So it could be if you've got a community like a Smithfield some 25 years ago, or a Santaquin or a Spring City that had to completely abandon all their septic tanks and put in a centralized wastewater collection disposal system. Yes, the board did incentivize that so that we don't have to deal with constant enforcement activities, and they can have a system that will keep their, be able to treat their waste satisfactorily. So there's an incentive that our board may provide. I can't speak on the federal level relative to any incentive.
I think it's much the same. Most recently, I've been dealing with situations where we're issuing compliance assistance plans to tribes, and have for years tried to work with the tribes who generally don't have anywhere near the expertise needed to run some of these systems. And so enforcement isn't the answer there. I mean, we can levy penalties. It's the budgets, especially where we're dealing with tribes that don't don't own land above oil and gas resources. They don't have the money. I mean, they could barely have the money to pay a penalty, let alone fix their system. So we're trying to go in with our expertise to deal with that, and then figure out a way that we can get these tribes to put systems in place to make sure that, the pump lift is going to run, and they're not going to have these lagoons that are dumping right into water that kids are playing in, and that, just atrocious situations. And there's not a great enforcement answer, so we're really, the focus on compliance and assistance is critical, I think.
So I think we have time for one last question.
I'd like to make one last comment if I could.
One last comment then.
So I was emphasizing throughout voluntarily disclosing, open communication, building trust, and it really is essential. But sort of the flip side of that is industry also should be, I think, non-apologetic if you don't think something's a compliance issue, if you don't agree with the state. Shouldn't feel in any way questioning whether you should challenge that. And if you've built that level of trust in the first instance, typically the state or the feds don't take offense. They understand. You disagree. But they understand that it's a principled disagreement because you've been open, you've been honest, you've been forthright in the first, over the course of time, and you just happen to have a principled disagreement here. That's an okay part of the process too.
So I think that's about the balance of our time. If you could please join with me in thanking our terrific panel